Funding for Current Conversations is provided by University of Oklahoma President's Office, University of Oklahoma Outreach, and World Literature Today. Welcome to Current Conversations. I'm R.C. Davis-Undiano. Today we're going to talk about issues affecting the LGBTQ community. We'll talk about some court cases and also some social issues that community is currently grappling with. To talk about these issues today, we have with us Professor Joseph Tighe, who is Presidential Professor and Glenn R. Watson Centennial Professor of Law at the University of Oklahoma. We also have with us Mr. Kasey Catlett, who is Program Coordinator for the Women's Outreach Center and Advisor to LGBTQ students at the University of Oklahoma. Guys, over the last 50 years, it seems like there's been a kind of social revolution going on, a real change in the way the country, the U.S., views and thinks about the LGBTQ community. This is huge, isn't it? I mean, really talking about a shift in the way people think about men and women and social life.
Absolutely. This is incredibly thrilling time to identify within the LGBTQ community. Representation is far more prevalent than it has been before. Laws, policies are going the direction of more equality. There's still a lot of work to be done, but the overall spectrum, it's a positive shift.
I think it's a very exciting historic time, but it's also a surprising time. Just 10 years ago, I don't think we would have imagined that we would be at the place we are today, on the cusp of recognizing marriage equality for the LGBTQ community. And the reaction that we saw to the law in Indiana these past few weeks, that would license businesses to discriminate against gays and lesbians, just illustrates how far we've come. Just 10 years ago, for example, we had a wave of laws across the country that banned gays and lesbians from marrying.
It's interesting that you emphasized how recent all of this is. I've looked at milestones for the sort of history leading up to the present moment for the LGBTQ community, and so much of what's happening starts really in the middle 20th century. I mean, we're talking about the last 50 years or so. Would a milestone for this be 1973, the American Psychiatric Association taking being gay off the list of diseases? I mean, would that be a good place to start?
You could talk about a multitude of things. Stonewall riots in New York City, but in 1973, when the APA removed sexual orientation from the list of mental disorders, that was a huge step forward into the idea of sexual orientation is an innate sense of self rather than a sickness or mental illness. However, even though sexual orientation has been removed, gender dysphoria is still listed as a mental disorder. Kind of pros and cons to that, but so it doesn't accurately expand on the entire LGBTQ spectrum. So transgender individuals wouldn't fall underneath that.
Something in 1979. What was that? There was something else.
So in 1979, it was the very first developmental theory that looked at lesbian, gay, bisexual individuals as kind of a development process, so the coming out process as well, and looking at it from a social, educational perspective rather than, again, a mental health illness.
So we see these movements of the culture kind of moving in this direction, sometimes just a half step, not a full thought, but just in that direction. But what happens in the courts is really, these are some ways the big milestones, right?
That's right, but courts often follow society rather than the other way around. For example, after the passage of the 14th Amendment and the guarantee of equal protection under the law, it took us a century, at least the legal profession, to recognize that separate, in fact, is not equal. And one of the central debates to the marriage equality question and the larger LGBT community equality question is whether equal also applies to people who are not straight.
Could you take us back to 1986, Bowers versus Hardwick?
Oh, sure.
That's an important case, right?
It certainly is an important case. So in Bowers v. Hardwick, the Supreme Court upheld a Georgia statute that criminalized same-sex intimacy. If heterosexuals engage in intimacy, that was fine. If homosexuals, gays or lesbians did it, then they would go to jail. And the Supreme Court said that there was no liberty interest that the LGBT community enjoyed in terms of intimacy. But the Supreme Court reversed itself 2 decades later in 2003 and recognized that this guarantee of liberty applied both equally to straight and to non-straight individuals.
What's going on here? I remember reading the majority opinion for Bowers versus Hardwick, and it's some moments that the justices sound like sociologists and historians. They're talking about their read of culture and what the culture will permit. And I noticed that some of the justices, like Sandra Day O'Connor, voted for the majority in '86, and then also for the majority on the other side in 2003. Is the court's responding to the culture, apparently?
I think so. I think Justice Kennedy put it best in his majority opinion in Lawrence. He said times can blind us to certain truths, and laws that were once thought necessary, in fact, later we discovered that they only served to oppress. And so I think the court takes time to come to the recognition that sometimes separate is not equal, and sometimes being straight or being gay or being being trans or bi, that has nothing to do with whether or not you deserve equal protection under the law.
And if there's an important ruling like the one you just talked about, that very often sets off other important rulings right after. In 2004, there is Goodridge versus the Department of Health in Massachusetts. What was that?
That's right. So in Goodridge, the Massachusetts Supreme Court decided as a matter of state constitutional law that in Massachusetts, their citizens deserved equal protection under the laws so they could marry an opposite-sex couple or a same-sex couple. It didn't matter. As a result of that decision, about 24 states, including Oklahoma, adopted constitutional amendments to amend their state constitution to ban same-sex couples from marrying. And so actually that decision that fulfilled marriage equality for Massachusetts citizens set off a backlash that pushed back the equality movement across the country, including in Oklahoma. And I had the privilege of working on the case here, Bishop v. Smith, that ended up just recently overturning that law in Oklahoma.
So would you talk about that a little bit?
Sure. So I represented two couples, Mary Bishop and Sharon Baldwin, and Dr. Gay Phillips and Sue Barton in Tulsa. And they had been together for decades, but they couldn't marry simply because they were the same sex. And so we challenged the Oklahoma constitutional provisions that banned them from getting married or that banned their out-of-state marriages from getting recognized. And we eventually got two federal courts to agree with us that those bans violated the basic guarantees of liberty and equality under the 14th Amendment.
Why, if federal courts come up with a ruling like that, why isn't that just it? Okay, the issue is settled. It's not settled, is it? I mean, there's in fact a case working its way through the Supreme Court right now.
Right. So there's a technical answer and then there's a social answer. And maybe Kasey can address the social answer. The technical answer is that it was settled for my clients and for thousands of other Oklahoma couples. And they are in fact married, and hundreds of other Oklahoma couples rushed to get married soon after that decision. But it's not settled for the country because our court victories have limited application, only application in the 10th Circuit, which is the region that we're under. As far as why isn't it settled socially, maybe Kasey can speak to that.
So socially, I mean, it comes from many sorts of cultural scripts that we don't have necessarily. So because we're born and socialized in a very heteronormative society, when we grow up, we're only seeing things in comparison. We're not born with vocabulary. We know that, we don't know, for example, myself, I wouldn't have known that I was gay at a young age because I don't have that vocabulary. All I know is in comparison to what representation that's involved. So, with my parents being heterosexual, kids on the playground, and representation in the media, movies, different things like that, marketing campaigns are all very heteronormative. So in the social context of representation of, or a lack of social scripts, is what does this look like for those who identify as lesbian, gay, bisexual, in the case of marriage equality, or I like to just call marriage. The social context is, what does this look like now? And we're talking about how quick all of this has happened, and most of this, I would say, comes with education, but a lot part of that education that's being disseminated comes from social media. Internet has made a huge impact on both kind of positive and negative, on the rise of LGBTQ issues and concerns and policies and whatnot. And so because of that, education is there. So individuals are having identities defined for them to say, this is how I identify, I fall into this category, I know that I'm not alone. Communities are built that way as well, but because this is such a huge rush in all of the change, then cultural scripts have yet to be defined. And so the question is now, what is LGBTQ culture? In the sense that we are not just one collective, we impact a lot of different areas of identities as well. And so those are some of the cultural aspects that come in with marriage equality on the rise, sweeping through the country, different things like that.
I get the impression it was something that is genuinely very complex and nuanced and multi-layered, as issues of who can marry, that the culture is sort of thinking this out. There are people that aren't aware they've ever met an LGBTQ person. They just have very little experience. But I remember when Matthew Shepard was basically tortured and beat to death in Laramie, Wyoming, that gets on people's screen. And so it's just one little area of awareness. Oh, that's what could happen to a gay person in this culture. So a little bit of the conversation sort of lights up for them.
Yeah, and it's unfortunate that events like that, these heinous events have to, are the ones that have to happen in order for progress to be made. And that's an example of that, and that shows in the Obama administration. President Obama created anti-bullying acts, Matthew Shepard and James Byrd Jr. Act, to prevent things like that and to help fund and raise awareness.
And they got Don't Ask, Don't Tell repealed in 2010. I remember when Don't Ask, Don't Tell seemed kind of socially progressive under Clinton, and then very quickly it's just sort of the old thing, and it's oppressing people, and now it's gone.
Yeah, I said earlier that law often follows society, but I guess in one respect I'm being unfair to law. I think law sometimes leads society, and in this very particular respect, after all of these marriage equality victories across the country, I think people are starting to see more often out there, gay and lesbian families, and to the extent that they see them as their neighbors and friends and their kids' parents, they'll start to just accept them as families rather than as gay or lesbian families. And that's a different kind of education, but that's one that I think...
So maybe social media in general is starting to play a role here, just because people are aware of a whole array of people unlike themselves in a way that they didn't used to be.
Yes.
Is that part of what's going on?
Absolutely. Social media plays a huge impact on connecting with people. Also, what you're seeing on TV, that there are more representation in television shows and movies, celebrities that are coming out, and many aspects from athletes. Then we see military individuals who are coming out looking for inclusion and representation as well.
It's maybe sometimes hard to remember when we're sitting here talking about this, and we've read a lot of things, and you're an expert on the law, and you're an expert on a lot of society and social movements and so on, that there are people sitting around the country who really never thought about this. It just doesn't come into the world. So they do need the conversation kind of filled out a little bit, and it's painful because it's one part at a time in that picture.
Oh, it is. I think now, just even in my classrooms, I notice a change. 10 years ago, I think students were confronting these issues for the first time, and they were big issues for us to talk about in the classroom. We've turned the corner, for this generation at least in the classroom. At the law school, for most students, it's not a big deal until the LGBT community is discriminated against, then it becomes a big deal. But I think in the broader society, there's still work to be done.
There's still a lot of work to be done. Again, we talked about social media playing an impact, but also the negative views of LGBTQ people, it's not looked at as an irrational fear or negative perspective. It is the messages that we receive, and that can be in many areas of community for some people. So there are still negative messages out there, and that can affect those who don't identify within the LGBTQ community, but then also those who do identify. A lot of internalized self-loathing.
In fact, one of the primary messages that states that are defending their marriage laws are making is that opposite-sex parents make the best parents. They're not saying anything disparaging about same-sex parents, but by implication, they're saying same-sex parents are not equal in their ability to raise healthy kids.
Would that be the strongest argument on the far right, or is that
actually not
the go-to argument for the far right?
That's all they have left. Let me just begin by saying it's absolutely not their strongest argument, because we've had decades and decades of social science literature from the American Sociological Association, from the American Psychological Association, that have shown that opposite-sex parents and same-sex parents, they have the same child outcomes.
Equal results.
Equal results, right. But it's the argument that is the last resort, because the Supreme Court has made clear now that a law that discriminates merely on the basis of moral disapproval is not rational under the Constitution. And so we know all of these laws are based on moral disapproval. And so once you set that aside as an illegitimate basis, then they have to turn to something. And what they've been turning to are sociological arguments that just don't hold up water.
Well, and the argument so often is that activist judges, you hear that term a lot, have gotten ahead of the culture. Communities aren't ready for this for whatever reason. So maybe we could still go back to the far right argument and the far left argument.
Sure.
What do you think the strongest, or at least most prevalent argument on the far right is at this point?
I think the strongest argument that they could make under the Constitution is just that, well, look, back in the post-Civil War days when they passed the Equal Protection Amendment, surely none of them were thinking about same-sex couples getting married. That wasn't the right that they were enshrining. So I think that would be the strongest sort of literal, historically frozen argument as to what our constitutional right to equality means. But I would just respond by saying it's often the case in our history that we adopt these great principles that takes us a long and painful epic of our nation's history to fully appreciate and realize separate but and not equal as one of them.
Would the strongest argument on the far left be the 14th Amendment, that we are committed to equal treatment for everyone in this country, and here's a area of just great exception, and we're going to correct it and go forward?
Absolutely. Talking about the argument on the far right, it's based off of antiquated perspectives or very limited educational information. And so from this point of view, from the left point of view, you have to look at it as we're all individuals, we're all part of the social climate of wherever we're located geographically, demographically, and whatever aspect. So the argument is that we're human beings and we all deserve those equal protections, equal rights that everyone else does.
And another argument I think is especially appealing, just given that the rights argument is that it's based on what's best for the kids, is that not only are same-sex parents equally capable of raising kids with great outcomes, but the fact that these families have to face challenges that opposite-sex families do not, they're denied the basic legal and social protections and financial protections of marriage, means that ultimately it's harmful for these kids that their parents don't receive, their families don't receive the same equal dignity and legal protections that every family
does. And it continues to perpetuate a stigmatization of that is anti-LGBTQ when it's those messages that we're receiving at a very young age of my parents are not treated equally. So those are the negative implications that are going into the children at a very young age.
I admire the way you can just kind of rattle that off, LGBTQ, because I have to think about it every time.
I have to practice too. So.
DOMA, passed the Defense of Marriage Act, passed in 1996, and it was repealed just, 2 years ago, 2013? Talk about that a little bit.
It was
Section 3.
Right. Well, it was stricken by the Supreme Court.
Okay.
So the part that the Supreme Court struck was the federal refusal to recognize valid same-sex state marriages. So in other words, in Massachusetts, one could get married to a same-sex partner, and federal law refused to grant any recognition or any benefits or any protections based upon that state marriage. And the Supreme Court said that's a basic denial of equal protection and due process under the 14th Amendment.
So, I mean, it seems like a slam dunk with applying the 14th Amendment.
Well, it does now, but so does Brown versus Board of Education, right?
Right.
But the same historical argument on the right that we alluded to earlier, if you go back to the post-Civil War days, certainly you could say that those folks who passed the 14th Amendment did not expect to outlaw segregation either. It just took us a century to realize that the equality principle that they adopted was greater than their practice.
The striking down of DOMA seems to, somebody coming from the outside, from another country might say, okay, they've sort of cleared that issue, it's taken care of. And this very year in 2015, we've got the Religious Freedom Restoration Act in Indiana and Arkansas. That looks like an attempt to be sort of clever and bring discrimination through another door. Is that the way you look at it?
That's the way I look at it. And the question is who's being discriminated at this point? And then the kind of the foundation of it, you have to question yourself, what is privilege and how is privilege being manipulated in this situation? And in the state of Oklahoma, privilege is identifying with your sense of religion, and then again in the state of Oklahoma, that religion is typically Christianity. And so in that aspect, to kind of manipulating that and saying, look, we're being discriminated against because our views of LGBTQ is in not a positive way. And so protect us, what can we do? How can you protect us? Which is now against those who identify as lesbian, gay, bisexual, and trans.
Yeah, and we have to keep in perspective that gay and lesbian and transsexual individuals, they're not asking for more than the general public. They're just asking to be married like anyone else can. They're just asking to be served at a restaurant or to be or to go to a public event. And so these religious freedom laws, what they really are intended to do is to allow people to single out classes of people that they disapprove and discriminate against them.
So if we were trying to do an ethnography of trying to understand the culture that produced these laws in Indiana and Arkansas, what would we probably find? People that believe that they're activist judges who are getting out in front of the culture and they just can't win because those judges are so prevalent. So they try to pass legislation that is has the appearance of being something else, religious freedom, but in fact it's discrimination all over again against LGBTQ people.
Throwing in everything but the kitchen sink at this point, where we've got one step forward, we've got a two-step back, different variations of that. So yeah, we're seeing
or maybe two steps forward, one step back.
Yeah, we'll go with that. 2 steps forward, 1 step back. So we're seeing a different climate now, where people are a little bit on edge on both sides. Of finally we're getting somewhere, but then we've got things that are going on in Indiana or California, different policies.
And similar bills were proposed in the Oklahoma legislature this year, by the way, but they
House Bill
pass.
1598, the conversion therapy bill. Could you talk about that?
Well, I can only talk about it from a mental health perspective and identifying within the LGBTQ spectrum, that we don't see it as a positive thing entirely, and it comes from the foundation that your sexual identity, your orientation, can be manipulated and can be changed, or it is a decision that one makes to identify within the LGBTQ spectrum, and that's not the case. It's an innate sense of self, and that's a very archaic point of view that you can change it, or that it's, again, a mental illness. And we know that the DSM removed it, in 1973, so it needs to continue to stay that way. So conversion therapy doesn't help anything. In fact, it does a lot more damage than it does good, based on the individual and then the community as well.
Is this the pattern we're probably going to see for a while? When there's an important piece of legislation or a court decision, we're probably going to see a step back somewhere else as a reaction to it?
Oh, of course. And in fact, the Indiana law and the laws that were proposed in our state house, they were, I think, anticipatory of the Supreme Court case that's going to come down the pipeline in a couple of months.
Probably in June of
in June,
2015.
that's right. Yeah, the last week of June. So the Supreme Court's going to hear argument in a couple of weeks on the marriage equality cases, and then they'll issue a decision with nationwide effect towards the end of June. And that's really important because, for example, in the Bishop case with my clients and the hundreds of other same-sex couples who ended up getting married after we won, they're married in Oklahoma as of today, but the minute they drive or fly over into another state where there's not marriage equality, they're divorced as a matter of law.
Yeah, those are the two issues, I think, in that case that the Supreme Court is looking at right now, right?
That's right.
The one issue of the right to get married,
Right.
and then the other issue is recognition of same-sex marriage from another state.
That's right. And it's important that we have a national decision so that these couples and their kids are protected wherever they go. I mean, it seems remarkable that we live in a balkanized marriage nation where the minute you step across the border, your status changes.
Want to stick your neck out and say what you think the Supreme Court's going to decide in June?
It's not much of a risk. I think it's going to be at least 5-4, if not 6-3, that they're going to strike down these marriage bans. It'll be another Loving v. Virginia. And just for historical perspective, Loving v. Virginia was a 1960s decision that struck down interracial marriage bans. In 1967, in fact, and in 1965, 2 years before the U.S. Supreme Court struck down the Virginia statute, the Oklahoma Supreme Court had unanimously upheld Oklahoma's statute. And so, we're part of this history.
I've heard that it might be a mixed decision that would satisfy both sides a little bit, where it won't guarantee same-sex marriage in every state, but it'll mandate recognition of same-sex marriage from another state that comes into your state. Have you heard anything like that?
I don't think they would do that just because I think that part of the job of the Supreme Court when they take these cases is to ensure uniformity of law across the country, and I just can't imagine them allowing the status and protection of marriage to change from one state to another.
Okay, the decision comes down at the end of June. Will this sort of settle the legal question for a while that same-sex marriage is the law of the land?
Until the Supreme Court reverses itself.
Yeah. From a legal perspective, I think it it does answer that question. But we have to remember that this is not the final product of anti-discrimination issues and discrimination issues involving LGBTQ people. So it's important to recognize that. And just because it's the law of the land that same-sex marriages are upheld, doesn't mean that they can't still be discriminated against. And we see that with in Indiana with caterers or florists, whatever, wedding planners who are discriminated against LGBTQ people.
But this is the case that people wanted. And didn't the court take this because the appellate courts were disagreeing?
That's right.
So it was time to actually do the definitive case.
Sure.
The country was ready for that.
That's right. That's right. And that, I think, just goes to show that the Supreme Court will probably issue a definitive decision that finally answers this question of whether or not gays and lesbians enjoy the right to marry. But it doesn't answer the broader question as to whether or not private individuals or businesses can discriminate against gay and lesbian couples.
Okay, time for the fearless forecast. I'd like you both to tell me something you think will happen in the next 10 years that will influence the LGBTQ community in some important way.
For me, I look at it that, again, it's not the end of issues revolving LGBTQ with marriage equality. My fear is that there will be a backlash. We're seeing this backlash. Anytime there's a positive
because
change,
of all this progress in the courts.
Yes, positive change, that there's now going to be something that pushes us back a little bit. Other areas that I would like to see change, workplace discrimination, that you can still be fired for identifying as lesbian, gay, bisexual, transgender, based off of your identity. And then also, what is the LGBTQ culture? How do we navigate what the backlash is, and how do we get past that?
Joe?
I think there will be a federal law that protects the LGBTQ community from discrimination within the next decade.
That's the note we want to end on. Thank you very much, both of you, for being on the show. I'm so glad that you could join us today. Please join us next time for more current conversation. Thank you for watching.